Copyright. Copyright is the legal right to prevent unauthorized copying of the expression of an idea, such as a book, a song, a movie, or a photograph. Copyright in Australia is regulated by the Copyright Act 1968. In order for a creation to be automatically protected by copyright law, 3 requirements have to be satisfied. The first requirement is that the creation is a work or a subject matter other than works. There are 4 types of work that are protected by the Copyright Act in Australia: literary works, musical works, dramatic works, and artistic works. Literary works are any form of original text: a book, a magazine article, a newspaper article, a journal article, a poem, even an email. A musical work is any original arrangement of notes. So a song is protected as a musical work. A dramatic work includes a dance routine or a scenario or script for a film. And an artistic work includes paintings, sculptures, drawings, engravings, photographs, and any other work of artistic craftsmanship. There are 4 types of subject matter other than works that are also protected by the Copyright Act: sound recordings, films, television and sound broadcasts, and published editions. So in order for a creation to be automatically protected by copyright law, it first has to be shown that that creation falls within one or more of these 8 categories of work. The second requirement is that the creation is original. And here the word original does not mean that it is necessarily distinctive or different. It simply means that it is the result of the person's own skill and effort, rather than the result of copying from another source. A minimal degree of creativity is required. In desktop marketing systems and Telstra Corporation, DMS used the data from Telstra's telephone directories to create searchable directories on CD-ROMs. The CD-ROMs replicated the layout of the Telstra directory, and the court decided that the telephone directories were protected by copyright as original literary works, even though the level of creativity was minimal. The third requirement is that the creation is expressed in a material form. Copyright law does not protect ideas, it only protects the expression of an idea. In John Fairfax and Sons and Consolidated Press from 1960, the court had to resolve a copyright dispute between 2 newspapers. The Daily Telegraph copied and published birth and death notices from the Sydney Morning Herald. The Sydney Morning Herald obtained an injunction prohibiting the Telegraph from doing so, and so the Telegraph instead published notices that used the information from the Herald's notices, but using a different wording and a different format. The court decided that the injunction had not been infringed. The Herald only owned copyright in the way the information was expressed, its wording and its layout, not in the information itself. It's not the originator of an idea who owns the copyright, but the person who first expresses the idea in material form. If I tell you my idea for a new film, and you then go ahead and make the film, you have not infringed my copyright, because I cannot own copyright in an idea that has not been expressed in a material form. However, when you made the film, you were the first person to express the idea in a material form, and therefore you will own copyright in the film. In Donahue and Allied newspapers, Donahue was a jockey who was interviewed by a journalist. The interviews were written up by the journalist and published in a series of newspaper stories. 5 years later, the journalist wanted to use the material from the newspaper stories in a book to be published by Allied newspapers. Donahue, the jockey, opposed the use of the material and claimed ownership of copyright in the interviews. The court decided that copyright in the interviews was owned not by Donahue, but by the original newspaper as the journalist's employer at the time. The ideas in the interviews may have been Donahue's, but it was the journalist who first expressed them in material form. Once the 3 requirements for copyright protection have been satisfied, copyright protection is automatic. It's not necessary to register the creation in order to gain protection. Why then do so many people use the copyright symbol in order to indicate that the creation is protected by copyright? The answer is because it then prevents somebody from claiming that they infringed the copyright innocently. If there was a copyright symbol and they copied the work, that means that they knew that they were infringing copyright, and therefore the legal consequences of them infringing the copyright will be much more serious. Once the requirements for copyright protection have been satisfied, the copyright owner will acquire certain exclusive rights, including, most importantly, the right to reproduce the work in a material form. Only the owner of copyright has the right to copy, and anyone else who exercises that right without the permission of the copyright owner will be infringing the owner's copyright. The owner of copyright also has the exclusive right to publish the work, to perform the work in public, to communicate the work to the public, which includes online communication, and to make an adaptation of the work. So if I own copyright in a book and you turn my book into a film without my permission, you will be infringing my copyright. How long does copyright protection last? It depends on the type of work that is being protected. Literary, dramatic, musical, or artistic works are protected for 70 years after the creator's death, or if the work was not published until after the creator died, 70 years from the date of first publication. After the expiry of this date, the work will enter the public domain and can be freely copied by anyone. Film or sound recordings are protected for 70 years after the date of first publication. Television or sound broadcasts are protected for 50 years after first publication. And published editions are protected for 25 years after first publication. These are rather long periods, but we have been, of course, creating literary, dramatic, musical, and artistic works for a lot longer than that, and there are many works that have entered the public domain, including many famous works of literature, such as the works of Shakespeare, Charles Dickens, Sir Arthur Conan Doyle, and H.G. Wells. The person who creates the original work will usually be the owner of the copyright in the original work. There is, however, an important exception where an original work is created by someone in pursuance of the terms of his or her employment by another person. Then the employer is the copyright owner. Independent contractors, however, usually own copyright in what they create. It's also very common practice for creators to assign copyright to publishers and employers. Copyright is infringed when a person exercises the copyright owner's exclusive rights in relation to the creation without their permission to do so. For example, they copy the creation without permission. In order to establish that copyright is being infringed, 3 requirements must be satisfied. First of all, a substantial part of the creation must have been copied, and substantial part here does not mean a fixed percentage, but rather the court will assess the importance of the part that has been copied. If the whole of the creation had been copied, then this requirement is clearly satisfied, but if not all of the creation has been copied, so for example only a small part of a film or a television program or a song, or only a few pages from a written text, then the court will have to assess whether or not the part that was copied was a substantial part. In Larrikin Music Publishing and EMI Songs, the Australian band Men at Work was accused of infringing the copyright of Larrikin Music by including in their famous song Down Under a snippet from the much older children's song Kookaburra Sits in the Old Gum Tree. Even though a very small part of that older song was included in the song Down Under, it was a clearly recognizable and well-known part of the song, and the court decided that yes, a substantial part of the Kookaburra song had been included in Down Under. The second requirement is that there must be objective similarity between the original and the copy. If it's a precise copy of the original, such as you downloading a film onto your computer illegally or photocopying a book without permission, then this requirement is clearly satisfied. This requirement becomes important when somebody copies an original creation but doesn't copy it exactly. So for example, they might copy a text but change some of the words. As long as there is still objective similarity between the original and the copy, then this requirement will be satisfied. The third requirement is that there is a causal connection between the original and the copy. It must be shown that the person who has been accused of infringing copyright had access to the original in order to copy it. If they did not and could not have had access to the original, and in fact they came up with their own creation independently, and it just so happens that their creation is objectively similar to the original creation, then there has been no infringement of copyright. It is only an infringement of copyright if the original has been copied. A person accused of infringing copyright may seek to rely upon a range of possible defenses. One of the most important of these defenses is the defense of fair dealing. Fair dealing is when the rights of the original copyright holder have been infringed, but they were infringed because the other person had a good reason for doing so. Good reasons for copying somebody else's original creation include for the purposes of criticism or review, for the purposes of parody or satire, for the purpose of reporting the news, for the purpose of judicial proceedings or professional advice, and a defense that is very important to academics and students for the purposes of research or study. In relation to that particular example of fair dealing, most people will be familiar with the types of copyright notices that appear next to photocopiers in libraries that explain very clearly that a person is entitled to make a copy of an academic text for the purposes of research or study, provided, however, that they stay within certain prescribed limits. The general rule is that as long as less than 10% of the original work has been copied, the copier can rely upon the defense of fair dealing.